My spouse refuses to work in my Illinois divorce. Marriage involves various roles and responsibilities, often leaving one spouse as the primary breadwinner while the other takes care of domestic duties. In an Illinois divorce, the non-working spouse can significantly impact the case, particularly regarding maintenance and child support. So, what can be done if your spouse refuses to work during your Illinois divorce? Legal considerations for maintenance in Illinois. In Illinois, maintenance, formerly known as alimony, plays a significant role when one spouse refuses to work. The court must determine whether the non-working spouse is entitled to maintenance based on several factors outlined in Illinois law. These factors include the income, property, and earning capacities of both parties, as well as the duration of the marriage and the standard of living during the marriage. The Illinois statute, 750 ILCS 5/504, a. also considers whether the non-working spouse delayed career development due to the marriage. If the court determines that the non-working spouse deserves maintenance, the amount awarded can be calculated through a specific formula for couples earning less than $500,000 annually. If the couple earns more than that, the court may award a fair amount of maintenance, as long as it is justified by the factors outlined by the law. In some cases, courts will impute income to a non-working spouse, which means the court will estimate the spouse's potential income based on their qualifications, education, and job opportunities. For example, even if a spouse is currently unemployed, they could still be expected to earn an income equal to the skills and degrees they possess. This can reduce the amount of maintenance owed by the working spouse. What to do if your spouse won't work? If your spouse refuses to work, the Illinois courts offer several options. The courts may require the non-working spouse to maintain a job search diary, which tracks the jobs they've applied for. While this measure aims to encourage employment, it often proves ineffective. Non-working spouses may also be pressured into a higher share of marital assets in lieu of ongoing maintenance, thus encouraging them to become self-sufficient. Additionally, child support is calculated based on both parties' incomes. If one parent refuses to work, courts can deviate from standard guidelines and calculate support based on the needs of the child. This ensures that child support is adjusted fairly, regardless of a parent's employment status. Understanding imputed income in Illinois divorce. When a spouse voluntarily remains unemployed or underemployed, Illinois courts can impute income to them. This process is based on what the spouse could reasonably earn, considering their job qualifications and the prevailing job market. Under Illinois law, a court may impute income if the spouse has deliberately chosen not to work or has turned down job offers. For example, the court might say, although you're currently unemployed, you have the qualifications to earn $50,000 annually. Thus, when we calculate your maintenance, we'll pretend you're earning this amount. This concept allows the courts to adjust maintenance or child support in a way that reflects the spouse's potential rather than their current situation. Courts may also reserve the issue of maintenance for a later date, giving the non-working spouse a chance to find employment before finalizing the divorce. This can encourage the spouse to seek a job and become financially independent, while still allowing for adjustments to maintenance in the future. Forcing your spouse to get a job. Illinois law places an affirmative duty on spouses to seek employment when requesting maintenance. This means that if a spouse is not working, the court can order them to actively search for a job and report their progress to the court. However, this tactic is often ineffective, as spouses determined not to work may find ways around this requirement. In some cases, a prenuptial or postnuptial agreement may help, by stipulating that a non-working spouse is not entitled to maintenance. However, if unforeseen circumstances arise, such as long-term unemployment or illness, these agreements could be challenged in court. Navigating divorce when your spouse refuses to work can be challenging. If you're dealing with this situation, understanding Illinois law surrounding maintenance, imputed income, and child support can help you build a strategy that protects your financial future. To explore your options and receive guidance from experienced legal professionals, contact the law office of Russell D. Knight at 773-334-6311. Our firm, located at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, is here to assist you in navigating these complex issues and helping you secure the best possible outcome for your divorce.